Stephen or like a Jessica, but I think we're just now.
Mr. Clark, give us just 1 second. I'm calling your case.
All right.
Dennis, jump in there and okay.
Before this morning's docket even begins, the courtroom is already dealing with confusion, missing witnesses, and technical chaos. What should have been a routine set of hearings quickly turns into a procedural maze involving jail transfers, missing defendants, and critical legal deadlines that could impact multiple cases. If you've ever wondered how much coordination it actually takes to run a courtroom, even for short hearings like probable cause conferences, this clip gives a real behind-the-scenes look. Attorneys, clerks, jail officials, and the judge all have to work together in real time, often juggling inmates who are in different facilities, digital evidence that hasn't arrived yet, and strict legal timelines that cannot simply be ignored. But the biggest question is this: what happens when the people who are supposed to appear in court simply aren't there? And how do judges keep the process fair when delays start piling up? Let's watch closely as the court tries to sort it all out.
Ms. Dennis, can you jump in the breakout room and ask the complaining witness to come out? We're requesting they come out and we can't get them out.
Okay, no problem, Your Honor.
Thank you. You had an exam today on Petaway. They didn't bring him?
So he was in the Wayne County Jail. I believe he got transferred on Tuesday to MDOC. And I don't know.
So we have to rid him?
Yeah. Okay. So we can just push it out.
Have to close the rooms. We're gonna have to close the rooms to get them out.
Close in 9 seconds.
All right. What was the other adjournment? Petaway and which other one?
Miguel Aaron.
Do you want me to double check out here, make sure no one showed up? We need to check.
Petaway was transferred to MDOC and we did a writ already. Okay. On Aaron. So, all right, we've got everyone in the courtroom. Oh, not yet.
I'm trying.
And Miss Maudlin closed the rooms too. So, Mr. Gazicki, do you have anything else? No? Okay.
Nothing else, Judge.
Thank you. And we just got, all right, while we're trying to get him out, Amy, can I call these other two? Even when you close the rooms, it won't bring them out?
Yeah, it's not working. It's like frozen. I've been trying to get back and forth in. It's frozen. Technical difficulties.
Check in clerk, need to know anything?
She went to
How'd she get a lunch before us?
Oh, Mr. Harris. All right. While we're trying to get this individual out, I have 251159FD, the People versus Miguel Monte Aaron.
Good afternoon. Well, good morning, Your Honor. It's Segura with the Neighborhood Defender Service, P86432, appearing on behalf of Miguel Aaron, who was not brought over from the Macomb County Jail. I am requesting to adjourn this matter in order to process a writ. I do have quite a few hearings on the 11th, Judge, if the court would allow us to push it out to the 18th. He is in custody on another matter, so he's not in custody on our case.
Okay. All right. The examination on August 18th. I will give our clerks time to get him, but he was written for a day. But I recall when we set this, we weren't sure if they could get him that quickly. Okay, can you do 11 a.m.?
Sure can, Judge.
All right, we'll set that one for the exam there. And then we have Mr. Petaway, and this is 251964FY, the state of Michigan versus Johnny Petaway.
Good morning, Your Honor. Alyssa Segura with the Neighborhood Defender Service, P86132, appearing on behalf of Johnny Petaway, who is not present in the courtroom. He was held in the Wayne County Jail. This court granted him a personal bond. Unbeknownst to us, he did have a parole hold. And so when he was granted personal bond, looks like MDOC picked him up. He is currently being held in the Charles Egler Reception and Guidance Center. So I would be requesting to adjourn this matter to the 18th as well, in hopes that we can prepare a writ and have him brought over.
All right, so we'll set the exam. This is obviously good cause if we hadn't already waived the 21 days. So we'll set this for August 18th at 10:30 a.m.
Thank you, Judge.
All right, thank you. Actually, I'm setting it at 11, which is when your other one is, because I've already got a few set at 10:30.
Okay.
All right, at 11 a.m. Thank you. All right, and were we successful?
I lost the main witness.
We lost them. Okay. This is 252147FY, the people versus Stephen Clark.
Good morning, Your Honor. Alyssa Segura with the Neighborhood Defender Service, P86432, appearing on behalf of Stephen Clark, who is present via Zoom. Mr. Clark, will you please state your name for the record?
Stephen Clark.
All right, it's a time and date set for the probable cause conference. What's the status of discovery?
Your Honor, I have received paper discovery in this matter. There has yet to be digital discovery received from the OIC. From my understanding, the prosecutor did request that discovery from him. So hopefully we can get that to us soon. But I am requesting to set this out until the 11th, Judge, if you have the availability, considering I don't have that discovery. And unfortunately, I haven't had a chance to speak with Mr. Clark.
All right, Mr. Clark, your attorney is going to speak to you. As soon as we're done, I'll put you in a breakout room to speak with Ms. Segura. Your attorney has just indicated that she still does not have all of the discovery. So she's asking for me to set the exam out to August 11th. And so she can receive the digital discovery and review it and prepare.
Now the court moves on to another defendant, and something interesting happens here that reveals how complex custody situations can be. The defense attorney explains that the defendant wasn't brought to court because he's being held in a different jail on another matter. That means this case technically isn't the reason he's in custody. This distinction is incredibly important legally. When someone is detained on multiple cases or under different jurisdictions, the court must coordinate transportation and custody status carefully. That's why the defense is requesting an adjournment to process a writ, a formal court order directing the jail or prison system to bring the defendant to court on a specific date. Judges typically allow this when there's good cause, especially if the defense hasn't had a fair opportunity to prepare or even speak with their client yet. But every delay adds another layer of complexity to the system. And think about it from the defendant's perspective. How do you defend yourself if you haven't even had a proper meeting with your lawyer yet?
You have a right to have a hearing within 21 days of the date of your arraignment, and this will take you outside of the 21 days. Are you willing to waive that 21-day rule so your attorney can prepare?
Yes.
All right, we'll set the exam in person at the 23rd District Court, August 11th at 11 a.m.
All right.
I will call the victim, Your Honor, and let them know.
All right, thank you.
Mr. Clark, just remain on Zoom. I'm gonna hop on and I'll talk with you in a breakout room, okay?
All right.
All right, so we'll put you in a room and she'll be right with you.
All right.
And I'm gonna come in and get a couple of dates, Amy.
Okay, and that concludes the morning docket, I believe.
We
Do you have one more?
Yes.
Oh, okay. And he's in House Counsel 1 for you.
Thank you.
All right. What do you have?
Or, well, you know,
Mr. Story.
Judge, I like the morning.
As the docket wraps up, we see the court finally address Stephen Clark's case. And once again, preparation becomes the key issue. The defense attorney explains that digital discovery hasn't been provided yet, which is a major problem because discovery contains the evidence needed to prepare a defense. Without that information, moving forward could compromise the defendant's right to a fair hearing. That's why the attorney asks to postpone the examination date. But here's the twist. Doing so pushes the hearing beyond the standard 21-day rule, a deadline designed to protect defendants from excessive pretrial delays. So the judge asks Mr. Clark directly if he's willing to waive that rule, giving his lawyer more time to review the evidence. Clark agrees, allowing the court to set a new hearing date. And this moment highlights something important about the justice system. Many decisions happen through procedural agreements like this, not dramatic verdicts. But now we want to hear from you. Do you think courts should strictly enforce deadlines? Or should flexibility be allowed when attorneys need more time to prepare? If you found this courtroom breakdown insightful, make sure to hit the like button, share your thoughts in the comments, and don't forget to subscribe for more real courtroom analysis and jaw-dropping legal moments.